Ladies and gentlemen, esteemed colleagues and cherished students, today as we gather in the esteemed halls of International Balkan University, I am filled with immense pride and honor. First and foremost, allow me to extend my deepest respects and warm greetings to our respected Rector Lütfi Sunar, our dedicated Vice Rectors, the distinguished guests, the former president of the Macedonian Constitutional Court, Salim Murati, who grace us with their presence, our revered professors who ignite us the flame of knowledge, and our vibrant students, the torchbearers of tomorrow. It is a privilege to stand before you as we continue our tradition of excellence, bridging worlds through education and discourse. Today marks a remarkable occasion in our academic calendar as we're about to enrich our minds and souls with insight from luminary in the field of constitutional law, human rights, and civil freedoms. We are honored to welcome Professor Zühtü Arslan, a distinguished figure whose life's work has been a beacon of scholarly excellence and a testament to the enduring power of law and justice in shaping humane societies. Professor Arslan's academic journey commenced at Ankara University, where he graduated from the Faculty of Political Science in 1987. His thirst for knowledge and dedication to human rights and civil freedoms propelled him towards obtaining a master's degree and a PhD in constitutional law from the esteemed Law Faculty of Leicester University, United Kingdom. In 2002, Professor Arslan earned the title of Associate Professor, and by 2007, he was recognized as a professor of constitutional law, marking significant milestones in his illustrious career. His commitment to legal scholarship led him to the European Court of Human Rights in 2001, where he completed a lawyer traineeship program, further solidifying his expertise in human rights law. Professor Arslan's academic contribution extends beyond individual achievements. As the president of the Police Academy of Turkey, he shaped the minds of future leaders through courses on constitutional law, human rights, and theories of the state, among others. His tenure at Bilkent University and Başkent University, where he taught Turkish public law and law and politics, respectively, underscores his dedication to nurturing critical thinking and legal scholarship. His scholarly works, including books on constitutional theory, freedom of religion under the European Convention of Human Rights, and the history of Turkish parliament, reflect a deep engagement with the nuances of law and governance. Furthermore, his role as co-author of Constitutional Law in Turkey and editor of a book on freedom of expression in the judgments of the US Supreme Court, alongside numerous national and international articles, position him as a pillar of legal scholarship. Perhaps most notably, Professor Arslan's appointment as a judge of Constitutional Court of Turkey and his subsequent re-election as president of the court underscore his profound impact on the legal landscape, balancing the scales of justice and democracy. As we prepare to embark on this intellectual journey with Professor Arslan, let us open our minds and hearts to the lessons and insights he will share. It is not just an opportunity to learn, but to be inspired, but a life dedicated to the service of justice and the betterment of society. It is now my distinct honor to invite the esteemed rector of the International Balkan University, a beacon of leadership and academic excellence, Lütfi Sunar, to grace us with his invaluable insights and opening remarks.
Hello, everybody. dear President of Turkish Constitutional Court, Professor Dr. Zühtü Arslan, dear ex-President of Macedonian Constitutional Court, President Salih Murat Bey, and our distinguished professors and students. We are today too much honored to host Zühtü Hoca here as a professor also in Balkan University about the constitutional law issue. After this introduction, I think all of you are waiting for listen Professor Arslan, and I want to extend my gratitude to him to join us today, and also to give an opportunity for us to think again about the constitutional court of the countries. It is an important issue. We are suffering in the world now about the constitutional issues. In our country, in Balkan region, we have many problems, legal problems. And today, Professor Arslan will share his vision and opinion about these issues with us. And I hope all of us will have an opportunity to think again these issues, these important issues again. Also, I want to say thank you, Professor Salih Murat. He made possible this conference. He invited Professor Arslan in our university, and he brought this opportunity for us to be benefited from this good academic vision. Thank you for coming and joining us.
I am now pleased to invite the former president of the Macedonian Constitutional Court, Mr. Salim Murati, to express his remarks.
Kıymetli hazırın, çok değerli Türkiye Cumhuriyeti Anayasa Mahkemesi Başkanı Sayın Profesör Doktor Zühtü Arslan, aynı zamanda benim dostum, kardeşim, hukukumu söyledi. Siz değerli protokol, her birinizi saygı, sevgi ve muhabbetle selamlıyorum. Tabii bugün bizim hem üniversitemize hem devletimizde çok anayasa yargı alanında, bireysel başvuruda, anayasa düşüncesinde dünyada en ileri gelen bilim adamlarından birini üniversitemizde ağırlamaktan büyük bir memnuniyet duyduğumuzu ifade etmek isterim. Tabii kıymetli dostumuz Makedonya'nın Anayasa Mahkemesi'nin 60. yıl dönümü vesilesiyle resmi olarak Makedonya'da bulunmaktadır. Biz de rica ettik kendisine. Onlar Allah razı olsun kırmadılar. İşte gelip kendi bilgi ve birikimlerini bizim hem üniversite hocalarımızla hem hukuk fakültesi öğrencilerimize paylaşmasını arz ettik. Yoğun programlarından dolayı bu üniversitemize gelmelerinden dolayı ve ağırlamaktan büyük bir memnuniyet duymaktayım. Tabii Zühtü Arslan Bey'le ilgili konuşmak böyle ona ayrı bir seminer ister. Ben 12 yıllık bir dostluğumuz var böyle. Makedonya'nın devletinin gerçekten Türkiye'de gönüllü büyükelçilerinden biridir. Ve bugün hem üniversitemize yapılanlardan hem Makedonya'ya gelen değişik hizmetlerde burada açıktan büyük emekleri vardır. Ben huzurunuzda saygı ve hürmetlerimi kendilerine sunmayı bir borç bilir. Tabii hukuk alanında bizleri de Makedonya'yı da bizim Anayasa Mahkememizi küçük bir devlet olmamıza rağmen büyük devletler statüsünü hep koymuştur böyle. Hem Türkiye'de hem dünya çapında. Ben hem bölgesel çalışmalarda, Balkanlardaki çalışmalarda hep beraber olduk. Avrupa'daki çalışmalarımızda değişik patronlarımız var. Dünya ekseninde de Makedonya'nın hep yanında olmuştur. Bundan dolayı kendisine bir Makedonya eski Anayasa Mahkemesi Başkanı olarak saygı ve hürmetlerimi sunarım. Profesyonel olarak gerçekten böyle değişik alanda ilan kaynağı olacak ilme sahip olduğunu ben hem Türkiye'de hem dünyada değişik yerlerde beraber olduğumuzda gururla dinlediğim bir meslektaşım, bir kardeşimdir böyle. Onun için Türkiye anayasa yargısına sanırım bilhassa bireysel başvuruya ve anayasa düşüncesine Türkiye'nin şu anda bu dönemde yön veren bilim adamlarından biridir. Onun için sözlerimi Türkçe son verirken bizim üniversitemizde böyle bir hukuk ve anayasa dehasını ağırlamaktan gerçekten büyük bir bahtiyarlık ve bugünü ben beklemişim hep böyle bir kardeşi olarak. Kabullerinden dolayı çok teşekkürlerimi sunarım böyle. Na makedonski podijam nekoliko zboravaka. Deneska i predstava особено чест и задоволство да имаме гостин, пријател, братски настроен према нашата држава, професор доктор Zühtü Arslan, инаку преседател и долгогодишен судија на Уставниот суд на Република Турција. Zühtü Arslan е меѓу најпознатите професори по уставното право, уставната мисла и уставното судство. Реформатор е вака, особено ако се анализираат анализите, светските анализи за напредувањето на Турција со индивидуалната жалба, ќе се уверите дека за во некои држави достигнувањето што достигна за 30 години, во Турција се достигнати за 5 години, благодарение на ценетиот професор. Од втора страна е многу ценет во светските токови. Јас сум бил сведок на разни светски конференции, на европски конференции, балкански конференции, представува еден авторитет во оваа проблематика. И третата особеност на ценетиот професор е многу пријателски и братски настроен према нашата татковина. Јас се знаеме околу 9-10 години и сите добрини што се во односите помеѓу Македонија и Турција сигурно има удел нашиот ценет пријател на нашата држава. И поради тоа упатувам најискрени поздрави и честитки што прифати денеска да биде гостин во нашиот универзитет, да сподели своите искуства со нашите професори и со нашите идни правници во вашето име, во името на нашиот борд на универзитетот, инаку јас сум и член на бордот на универзитетот, и во името на нашиот ректор и другите ценети во управата, упатувам најискрени поздрави и честитки што прифати да биде нашиот денешна гостин. Благодарам.
With great anticipation and respect, we now invite Professor Zühtü Arslan, the President of the Constitutional Court of Turkey, and our esteemed guest lecturer to enlighten us with his expertise and commence this much-awaited lecture on the topic, Why do we need constitutional justice?
Distinguished Rector of the International Balkan University, distinguished former President of the Macedonian Constitutional Court, dear Vice Rectors, Professors, Lecturers, and dear students. It's a great pleasure for me to be here again and to address such eminent participants. I said again because I was here 6 years ago to talk about the future of constitutional justice in Turkey. Today I am here to talk about the question of why do we need constitutional justice. It will take about half an hour to answer this very simple question. It is simple, but it is a very crucial question, actually. The term constitutional justice is needed to be described at the very beginning of such a conference. Constitutional justice is a generic term used for the jurisdiction of constitutional courts and equivalent bodies who have the competence to review the constitutionality of laws and executive decisions. So it involves the activities in the field of constitutionality review as well as individual application, otherwise known constitutional complaint. Why do we need constitutional justice? As we all know, constitutional justice also consists of two main words, constitutional and justice. So in order to properly reply this question, we have to first reply the question of why do we need a constitution? And then we have to also answer the question, why do we need justice? And replies to these basic questions will bring us to the replies to the main question of necessity of constitutional justice. Let me begin with the first clear question. Why do we need a constitution? The answer to this question lies in the nature and characteristics of power, especially legal and political power. Unless we understand the nature and characteristics of the power, we cannot understand the meaning of the necessity of a constitution. The power may be defined as the ability to decide on certain issues and enforce and impose one's will over others. In this regard, legal and political power lies in the will to create, apply, and impose rules on the people. As the British historian Lord Acton once said that power tends to corrupt and absolute power tends to corrupt absolutely. So this is a very basic indication of the nature of power. And history reveals that Lord Acton was right. Unless the power, especially political power, is restricted, it will lead to corruption. It will lead to arbitrary restriction of our rights and liberties. And the origins of desire to restrict power goes back to early history. I will talk about what is known as Gilgamesh epic. In the Gilgamesh epic, we see that the gods were trying to restrict the king Gilgamesh's power, oppressive power, because people of Uruk, or Iraq in today's term, were complaining about the oppression of the king Gilgamesh. He was an oppressor, and the gods talked about the way of restricting the power of King Gilgamesh, and they decided to create another powerful half-god man called Enkidu. So Enkidu was created to control or to balance the power of King Gilgamesh. But this project ended in failure because eventually Enkidu became a good friend of King Gilgamesh. So that's why the project failed, but the desire for controlling and restricting the power of the politicians remained to continue. And today we know that this seek for controlling the power of the rulers still continue. This ancient epic also reveals that controlling power is indispensable for the protection of rights and liberties of individuals. Ibn Khaldun, who is known as the founder of sociology, emphasized that human rights should be protected for the continued existence of the society and the state. The concept used by Ibn Khaldun was hukuk an-nas in Arabic. Hukuk an-nas means human rights. Ibn Khaldun consistently told us that the state, the society must protect hukuk nas, human rights of individuals. If we want our state endure or continue for a long time, we have to respect rights and liberties of individuals. That is the essence of Ibn Khaldun's message for us. And he actually also defines the injustice behavior of the states as zulm, oppression. Ibn Khaldun told us that if the state oppresses its subjects, it will not continue to exist. More importantly, Ibn Khaldun states that the rights of human beings should be safeguarded in judicial field, and that the responsibility in this regard rests with the judges. So judges are responsible for ensuring the protection of rights and liberties of individuals vis-a-vis the political power. So it wouldn't be wrong to say that constitutions and constitutional justice are the culmination of the long process of striving to control the political power. In other words, we need a constitution to effectively control the rulers and protect our rights and freedoms. There are two constitutional principles that serve to limit the powers of the rulers. First, the principle of rule of law. It is a basic principle that we should have in order to protect our rights and liberties. Modern constitutions, almost all of them, contain certain provisions protecting the principle of rule of law. For instance, Article 8 of the Macedonian Constitution clearly says that rule of law is one of the fundamental values of constitutional order. Article 2 of the Turkish Constitution also clearly says that Turkish Republic is a state based on the rule of law. So it is a principle which is an eternal clause. That means it cannot be changed, it cannot be amended. So it is one of the cornerstones of the constitutional order of Turkish Republic. The second principle that serves to restrict political power in the way of protecting rights and liberties of individuals is the separation of powers. It is believed that the powers of legislation, executive, and judiciary must be separated from each other. And they must be vested with different organs or different bodies. As Spinoza warned us centuries ago, to entrust affairs of the state absolutely to any man is quite incompatible with the maintenance of liberty. That means if you leave the power of legislation, executive, and judiciary to one organ or to one person, forget about the protection of liberties. Like the rule of law, the principle of separation of powers is a sine qua non condition of modern constitutions. Again, Article 8 of the North Macedonian Constitution enumerates the separation of power as one of the fundamental values of constitutional order. Article 16 of the Declaration of the Rights of Man and of Citizen, which is part and parcel of the French Constitution, went even further by stating that any society in which no provision is made for the separation of powers has no constitution. That means every constitution must contain a provision dealing with or protecting the principle of separation of powers. The preamble of the Turkish Constitution provides that separation of powers doesn't imply supremacy or superiority among the relevant bodies of the state, but a civilized cooperation and division of functions. the Constitutional Court of Turkey has interpreted the separation of powers as a vital safeguard for the independent judiciary. Distinguished participants, ladies and gentlemen, so far I have tried to answer the basic question as to the nature and necessity of the constitutions. Now I would like to turn to the second relevant question of why do we need justice? There is no doubt that the most significant indicator of the contemporary civilization is to secure justice. To borrow the words of the great Kazakh poet and thinker Abay, we can say that justice is the mother of all other values. So justice is the foundation of all our moral and legal values. This value has played a significant role in the lives of states and societies. At this point, I would like to mention a concept called the justice circle or the circle of justice. In Turkish, daire-i adalet or daire-i adliye. This is a principle that dominated over the legal and political order of the Ottoman state. The circle of justice amounts to certain elements of the state, such as people, army, money, and justice. It is formulated and summarized as follows: no power without troops, no troops without money, no money without prosperity, no prosperity without justice and good administration. That is why justice is the foundation of the state. As the foundation of any social and political entity, justice maintains order and ensures happiness of the people. What is justice then? How we can define or describe the term justice? We have to look at the writings of Mevlana Jalaluddin Rumi to find an answer to the question of what is justice. Mevlana Jalaluddin Rumi centuries ago gave one of the most comprehensive and still relevant answer to the question of what is justice. He said that justice is to put everything in its right place, to put everything in its proper place. In concrete terms, Mevlana told us that to give water to trees is justice. But to give the same water to thorns is injustice. So you have to be careful while defining the term of justice. Mevlana also emphasized the role of justice in the society, in the social life. He regarded the judge who applied the law to resolve conflicts in a peaceful way as a mercy bestowed by God and the means of removing strife. He said that judge was a drop from the ocean of the justice, because judges are in a position to resolve social legal problems without resorting to violence. This definition and function of justice given by Rumi is still relevant today. We need law to solve our problems without killing each other, and also need justice to put everything in its right place. In today's political language, justice refers to the protection and promotion of rights and liberties of individuals. Now, I have to raise another question to better grasp the nature of constitutional justice. Do we need anybody, any organ to protect constitution and constitutional principles and the rights and liberties of individuals? As we all know, constitutions are also described as social contracts by which people set down the conditions for living together. Any contract requires a body or bodies to guard its terms and provisions against possible violations. There is no doubt that constitutional courts were established with the objective of preserving and protecting the Constitution as a social contract. Therefore, behind the idea of constitutional justice lies a widespread belief that the constitutional courts are in a better position to protect the Constitution itself and the constitutional principles enshrined in any constitution. In fact, the idea of judicial review by a centralized constitutional court emerged from a fierce debate among two leading German-speaking lawyers, namely Kelsen and Carl Schmitt. They both tried to provide a convincing answer to the following question: who is the best guardian of the Constitution? Kelsen replied this question by stating that a centralized court called Constitutional Court is in a better position to guard the Constitution. But Schmitt objected this view by referring to the analogy that creating a special court to review the constitutionality of law was not different from making the fox as the guardian of hen house. Following the gross violations of human rights before and during the Second World War, Kelsen's argument prevailed not only in Europe, but also in most parts of the world. That's why after the Second World War, in many European countries, constitutional courts were established to curb political power and to protect the Constitution and constitutional rights and liberties. And today, a centralized constitutional adjudication is widely adopted as an effective way of controlling legislative and executive powers. At this moment, I want to turn to the topic of the constitutional justice in Turkey. I will briefly talk about the role and function of the Constitutional Court of Turkey in protecting the rights and liberties of individuals, as well as upholding the constitutional principles of rule of law and separation of powers. I can say that Turkish Constitutional Court has become the main guardian of the constitutional principles in Turkish legal system. This role of guardianship is more visible in its decisions and judgments concerning the protection of rights and liberties of individuals. So it wouldn't be an exaggeration to say that with the help of the adoption of individual application or constitutional complaint, the Constitutional Court has abandoned its deeply embedded ideological or state-based paradigm and instead adopted what I call a rights-based legal paradigm. The rights-based paradigm assumes that freedom is the rule and restriction is the exception. This approach requires that the Constitution must be interpreted in favor of protecting rights and liberties of individuals. And the constitutional provisions must be interpreted in a way that gives certain priority to the protection of rights and liberties. The paradigm shift in the jurisprudence of the Constitutional Court of Turkey can clearly be seen in its approach to the headscarf issue. In Turkey, as the case in some part of Europe, intense discussions had taken place on the constitutionality of headscarf ban in universities and public spheres. Before adopting the rights-based approach, the Constitutional Court even annulled a constitutional amendment that aimed to lift the ban in the universities. The court ruled that amendments, constitutional amendments in the way of lifting the ban on headscarf contravened the constitutional principle of secularism, which is enshrined as an unamendable clause under Article 2 of the Constitution. However, with the adoption of the rights-based paradigm, the court has radically changed its view towards the concept of or principle of secularism. In 2014, the Constitutional Court examined a case of individual application, which concerned a female lawyer's expulsion from a courtroom for wearing a scarf. The trial judge had decided that the lawyer's presence in the hearing with her headscarf was contrary to the principle of secularism under the case of the court, Constitutional Court of Türkiye, as well as the European Court of Human Rights. When the individual application came to the Turkish Constitutional Court, the court held that interference with the applicant's freedom of religion didn't meet the constitutional requirements of lawfulness or legality. This was so because there was no law preventing any lawyer from wearing headscarf at courtrooms. The court also stated that no reasonable and objective basis was presented for preventing the applicant from taking part at the courtroom by wearing headscarf for her religious convictions. Therefore, the principle of non-discrimination was violated since the applicant was put in a disadvantageous situation compared to those female lawyers not wearing headscarf. With so many judgments like this, which resolve the chronic legal disputes, the court has provided an immense and invaluable contribution to the establishment and maintenance of a just constitutional order. Distinguished participants, ladies and gentlemen, to conclude my speech, I would like to say that we need constitutional justice to curb the excessive political power, first. And second, we need constitutional justice to maintain peaceful coexistence of people by protecting their fundamental rights and liberties. With these two functions, constitutional courts make a great deal of contribution to appeasing social tension and sustaining social peace. And we all know that as one of the indispensable pillars of constitutional democracy, Turkish Constitutional Court plays a very significant role in protecting rights and liberties of individuals, as well as upholding the principle of rule of law and separation of powers and other constitutional principles. So we are doing, as the Constitutional Court of Türkiye, we are doing our best to protect rights and liberties of our people. Thank you very much for your patience and attention. If you have any question, I will be ready to answer them. No question? So that means everything was so clear that you don't need to ask any question. Okay? Sure, please.
You mentioned about the Schmittian perspective.
Yeah.
Maybe we may discuss a little bit more about it. What about the Schmittian perspective of exemption of some rules and of some regulations? Is there any cases in Turkey or in somewhere else that is making Schmitt right?
Well, this is a very good and very complicated question, actually. Thank you for this wonderful question. Well, the debate between Kelsen and Schmitt is very complicated debate, and it still continues, actually. There are many people who found Kelsen as a right thinker for our today's needs. And many others see Schmitt as a realistic philosopher or legal scholar for today's requirements or conditions. I personally believe that Kelsen was right and is still right in thinking that we need a centralized constitutional court to protect rights and liberties vis-à-vis the parliament and the government, executive. Schmidt was thinking about, I think, a Weimar Constitution while objecting to the idea that constitutional judges are in a better position to protect our rights and liberties. Many people believe that he was realistic, but his realism was quite compatible with the Nazi ideology of that time. As we all know that Schmidt's ideas were in a way abused by the Nazi government in Germany, or I would say that even some of his ideas, like the distinction between friend and foe enemy, as the basis of politics, was suitable for actually accommodating these ideas to promote the fascist or Nazis ideology. Yes, Schmidt is realistic thinker, perhaps, but in sometimes, especially in hard times, in difficult times where we have difficulties in protecting our rights and liberties, we need some idealistic ideologies or views to protect our rights and liberties. So we need Kelsen, actually, or Kelsen's ideas to protect rights and liberties in hard times. So I still believe that Kelsen's argument is still relevant, and on the contrary, Schmidt's ideas are very dangerous in certain terms. As you all know, Schmidt also argues that we need a homogeneous society to establish a successful democracy. So it is against the idea of pluralism. But we live in a diverse society. We live in a plural society. So pluralism is one of the most important and significant pillars of our contemporary society and state. So any idea which is against the idea of or value of pluralism might be reconsidered and talked twice. So I think the question why do we need constitutional justice is better replied by the arguments of Kelsen rather than the arguments of Carl Schmitt. Thank you very much. Is there any other question? Please. You can use microphone. I think we better hear you.
Thank you so much. First, my gratitude for this outstanding lecture on such an important topic, very specific. Also to International Balkan University for organizing this event. So to Judge Sami Murad and also to our director, Professor Dr. Zühtü for this opportunity. I was inspired by the topic, by the discussion on protecting the human rights and freedoms. So my question is, what is your opinion about the constitutional complaint as the legal remedy in terms of protecting the human rights and freedoms and the role of the constitutional court in that regard? Because in our legal system in North Macedonia, we have this limited set of rights and freedoms that can be protected on the basis of constitutional complaint. So there are some ongoing discussions about reforms, and I would love to hear your opinion. Thank you once again.
Thank you very much for this excellent question. Well, constitutional complaint or individual application is an effective remedy for protecting rights and liberties. It's a very effective instrument to protect rights and liberties, but there are certain conditions for the constitutional complaint to be an effective remedy. European Court of Human Rights has set certain conditions for being an effective, for having an effective constitutional complaint system. For more than 10 years, 12 years actually, we have been exercising the right to individual complaint in Turkish legal system. In 2012, we have started as the Constitutional Court of Turkey to receive individual applications on the ground that someone's rights or liberties guaranteed under the Constitution of Turkey and also the European Convention on Human Rights are violated by the public power. So far, the Constitutional Court has successfully exercised the power to receive or the right to lodge individual application before the Constitutional Court of Turkey. And as I said in my speech, we have resolved so many chronic legal problems of the country through individual application system. Because when you look at the constitutionality review, the courts are confined to in a way, abstract interpretation of the constitutional provisions. But when you face the constitutional complaints or individual applications, you see the application of the law and you see the practical problem. And you are in a better position to understand the aspects of the question, the problem, and you are in a better position to find a right answer to the legal dispute. So the individual application system in Turkey has significantly contributed to the solution we found in terms of protection of rights and liberties. I am sometimes asked whether I should recommend the adoption or introduction of individual application system in any country. Well, it depends. I remember that in 2015, I just became the president of the Constitutional Court. We had some visitors from Indonesian Constitutional Court. The Chief Justice of Indonesian Constitutional Court, who was still is a good friend of mine, Arif Hidayat, asked me whether I should recommend them to adopt individual application system, because as the Macedonia, they were at that time considering to introduce individual application system. And I told them, be careful, because it is a good and effective way of protecting rights and liberties. It's a very important instrument of constitutional justice, that is for sure, but it is also at the same time dangerous in terms of having some potential of case load, heavy intensified case load, because Indonesia is a very populated, much populated country. It's about more than 200, I think, to 150 million population living there. So when you provide the right to individual application to in a country like large populated country like Indonesia, you have to be careful, because in Turkey, for instance, we have the problem of case load. So we have now over 100,000 individual applications pending. So it is a formidable challenge for the constitutional courts to deal with this case load. But still, I will recommend the production of constitutional complaint system in any constitutional democracy. This is also the case or the opinion of Venice Commission. Venice Commission frequently advises to adopt a constitutional complaint system in the countries who are member of the Council of Europe. Thank you very much. Any other question? Okay.
Thank you very much for a very nice lecture. Even professors can learn a lot, although I'm not coming from the area of law. You started your presentation with power and division of powers. Having in mind the history of Turkey, I would like to ask you what is the position of military power now in the new constitutional order?
Well, it's a good question again. Thank you very much for this question. Well, as you know, Turkey has went through certain constitutional amendments, changes. We have changed the constitution for about 20 amendments we have so far made in our constitution. And all these constitutional amendments also change the relationship between the bodies of the state. Military used to be a dominant actor in Turkish politics, as we all know. But after the constitutional changes and also political changes, now the military is in a professional manner in a place where it must be. So in a civilian democracy, in a constitutional democracy, military must be subjected to the civilian democratic power of politicians. So the relationship between civilians and military has normalized in Turkey. I can only say that. Thank you very much. And another question.
I want to ask you, thanks for the presentation. As a question, investing a game theory between legal experts and political scientists, and a forecast for future side of the legacy, the law. Thanks.
Well, I think in the future, in both politicians and legal experts will play a very important role in terms of upholding the constitutional principles such as rule of law and separation of powers, because we need both, actually. We need legal experts, we need lawyers, judges, public prosecutors, we need judiciary, we need also executive, we need legislative power, we need parliament. So I think the best way of founding and maintaining a healthy political regime or a state is to keep a delicate balance between these powers. When we keep a delicate balance between these powers and the bodies using these powers, I think we can resolve many problems we have today. Thank you. Okay.
First of all, I want to thank you, Professor Dr. Zühtü, for your great presentation. We learned a lot regarding the constitutional justice. Actually, Professor, my question to you is more on a global scale, basically to hear your opinion regarding the balance of powers. Do you believe, Professor, that nowadays in the world from the democratic world, we have a pure balance of powers, as you asked, Professor. Thank you.
Well, I'm not an expert in international politics or international relations, but we don't need to be an expert to see that there is no balance of power at international or global scale. No. And we need justice also at international level, not only at national level, at the constitutional level, but we need to provide, to establish justice in international relations. And we see the many and cruel examples of injustice going on in the different part of the world nowadays. Thank you. I think that was the last question. Thank you very much for your attention again and your patience. It's a bit warm room. That's why, and the topic is also very warming. Therefore, I think we have to stop here. I'd like to again thank dear Rector for this warm hospitality and former Chief Justice or President of Macedonian Constitutional Court, all the professors and students of International Balkan University. I wish you very good and successful days. Thank you very much.
We extend our deepest gratitude to Professor Zühtü Arslan, the esteemed President of the Constitutional Court of Turkey, for sharing his extremely valuable insights, knowledge, and expertise today. We now cordially invite him to accept a token of appreciation from International Balkan University and our respected director, Professor Lütfi Sunar, as a symbol of a profound thanks and the enriching connection forged today.
Evet, teşekkür ediyoruz. Evet, katılımcı olarak evet.
And to all of you, professors, rector, vice rectors, students, guests, thank you for your participation, interest, and hopefully everything you have heard today has not only inspired you, but expanded your horizons and outlook of life. Thank you and have a great day.